Valuation of goods based on Section 14. Section 14 of the Customs Act 1962 prescribes the mode of identifying the value of imported and exported goods for the purpose of payment of customs duty. The provision of Section 14 was discussed below. Transaction value. So it is done by section. So subsection 1 lays down the purpose of Customs Tariff Act 1975 as the other law from time being imposed. The value of imported goods and exported goods shall be transaction value of the goods. In the case of exported goods, transaction value will be price actually paid or payable for the goods when sold or exported from India from the delivery at time and place of exportation where the buyer and sellers are not related, and the price on the sole consideration for the same. However, the further conditions may be specified in the rules made in the record. In the case of imported goods, the transaction value shall be the price actually paid or payable to the goods when sold out of export India for delivery time and place of exportation. And the place and buyer and seller of the goods are not related, and the prices are solely consideration sale. However, the case also for the condition is specified in the rules and made in the record. Such transaction value shall be included additional price and therefore said the amount payable in the cost of service include commission, brokerage, engineering, design work, royalties, license fees, cost of transportation of goods, sign protection, insurance, loading, unloading, and insurance to extend to the manner specified in the rules of the behalf. Such rules are provided by the circumstances in which buyer and the seller shall be deemed to be related. Such rules may be provided. The manner of determining the value with respect of goods when there is no sale or the buyers and sellers are related. The price is not the sole consideration of the sale as the case may be. The manner of acceptance of the rejection of the value declared by the importers as the case may be, where the proper officers may be reason for doubt of the truth and accuracy of the value and determine the value of the purpose of the action. So, in addition, obligation of importer is respect of any class of imported goods and the checks to be excised, including the circumstances of manner of excising. Therefore, the board may specify whether the board has reason to believe that the value of such goods may or may not be declared truthful or accurate, being regarded to treatment of declared value of such goods as may be relevant criteria. Other provision of the measure to address of the issue of undervaluation of importers and provide the rules to be framed by central government, whereby the boards can be enabled specific additional obligation to the importers respect of the class of imported goods. The values not being declared correctly, the criteria of the selection of such goods as the checks with respect to the goods. Customs Assistance Value Declaration of Identified Imported Goods Rules 2023 CAVR 2023 notified the aspect of the rules therein. The process of follow before the board may specify the class of imported goods and which there is a reason to believe that is a value may and not the declared value may not be declared truthfully or accurately, but below it is identified goods. The procedure of the importer of identified goods once the relevant class of goods has been specified and identified goods by the board. These include declaring certain aspects while filing the bill of entry. Further, it requires by the customs or the automated system such importers shall also file the specified additional obligation and specified check shall be performed so as to enable and assess the importer to demonstrate the truthfulness and accuracy of the declared valuation. Specified specification that where the proper officer will have a reasonable doubt about the truth and accuracy of the value declared relating to the identifiable goods, and further proceed shall take in accordance with section rule 12 of the customs valuation determine the value of imported goods or sovereign only. The CERV is applied only for the following process relevant to the rules. A written reference must be made on the board which found suitable for screening committee for the detailed examination must have been comprehensively examined by the evaluated committee, which should have excluded the likelihood of the value of the relevant cost of goods and may be declared truthfully. However, having regard to the trend of the declared value and the relevant criteria, therefore, the screening committee recommend configuration of the completeness of the report may have made by the board which satisfy that the recommendation should be accepted. Board may specify the identified goods exemption. The rule shall not be applied to imports not include duty. The duty goods of tariff value has been fixed by the board terms of section 14.2 of the Act. Goods which attract import duty on specified rate of duty. Imports in terms of authorization, the license issued under the duty exemption scheme of the Foreign Trade Development and Regulation Act 1992, in which the importer prior to the export of physical conditions of the export product. Imports where buyers and sellers are related and the investigation relationship has been already been confirmed and finalized. Project imports, import by the government, public sector undertaking, imports made in non-commercial quantities, goods imported for the purpose of re-export, imported specified by the board. Notification 0323 CUS 19 dated 11 1st 24 related to circular 123 CUS dated 11 123. Conversion date. The imported goods conversion of the rupee shall be done with reference to the rate of exchange relevant to the date of filing bill of entries under section 46. For export goods, conversion of the value has been done in respect of the date of exchange relevant to the date of filing shipping bursts on bill of export under section 50. In the case of Summer Timber Corporation account 1995 ELT 549, it was held that the relevant date of respect of the date of duty payable is the date of presentation of bill of entry, not the date of representation of fraction. Currency conversion rate. The rate of conversion notified by the three agencies: Central Board of Indirect Taxes and Customs Board, Reserve Bank of India, and Foreign Exchange Dealers Association India. For purpose of customs valuation, rate of exchange may be made by the rate of exchange determined by the board association of the manner as the board member. For the conversion of Indian currency into foreign currency and foreign currency into Indian currency, thus for the purpose of valuation of the customs law and rate notified by the CBIC board shall be taken into account. The CBIC notify the rate periodically, generally ever fortnight. There are separate rates for import goods and export goods. Foreign currency and Indian currency have meaning respective assigned to them in the clause M and clause Q of section 2 of Foreign Exchange Management Act 1999. Tariff value. The subsection 4 or 2 or subsection 14 provides that the board may fix a tariff value for any class of imported goods and export goods, being heard on the trend of the value of such or like goods by notification of official gazette either satisfy the necessary to do so. Where any of the tariff values are fixed, the duty shall be chargeable reference to the tariff value. Provision subsection 2 have override the effect of provision subsection 1 provided for the tariff value. Custom valuation determined by the value of the imported goods rules 07. Notification 94/2007 CUS 9 dated 13/9/2007 notified customs valuation determine the value of imported goods rules 2007 apply to the imported goods and rules are given below. Rule 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. So rule 2 definition, rule 2 determination method of valuation, rule 4 transaction value of identified goods, rule 5 transaction value of similar goods, rule 6 determination of value where the value cannot be determined under rule 3, 4, 5, rule 7 deducted value, rule 8 compounded value, rule 9 residual value, rule 10 cost and service, rule 7 declaration of import, rule 12 rejection of declared value, rule 13 interpretation of goods. Rule 2 definition. These rules, unless the content otherwise required, the computed value means the value of imported goods are determined according to Rule 2. Rule 8. Reductive value means value determined according to Rule 7. Goods are the same class of kind means imported goods that within the group of range of imported goods and produced by the specific particular industry or industrial sectors are including identified goods and similar goods. Identified goods means imported goods. These are similar in all cases. These are same in all cases, including physical characteristic, quantities, reputation. Goods has been valued except from the minor differences in appearance. They do not affect the value of the goods. Produced in country in which goods being valued under this product. Produced by the same person who produced the goods, where no such goods are available. Goods produced by different person but shall not include imported goods where engineered, developed work, not work, designed, planned, sketched, indicated in India, where the complete directly indirectly by the buyer on the imported goods are free of charge or reduced cost of use in the connection with the product and the sale of export in the imported goods. Place of importation means a custom station where the goods are bought by being cleared for the goods consumed or being removed or deposited in warehouse. Produced including grown, manufactured and mined. Similar goods mean imported goods. Well, this, although it's not like to be all respect, having been characteristics like component material which enable them to perform some functions and to be commercially interchangeable with the goods being valued, having regard to the quality, reputation and existence of the trademark. Produced in the country in which goods has been valued where produced. Production of the same person who produced the goods being valued where no such goods are available. Goods produced by a different person which shall not include imported goods where the engineer developed the work on artwork, design works, plans, sketch undertaken in India were complete directly indirectly by the buyer on this imported goods free of charge at the reduced cost at the use of connection with the production or the sale of the export of the imported goods. Transaction value means a value referred to subsection 1 of this rule, section 14 of Customs Tariff Act 1962. For the purpose of this rule, person shall be deemed to be related only if there is an officer or a director or one of the other businesses. They are legally recognized partners in the business. They are employers or employee. Any person directly, indirectly owns, control, or holds 5% or more than outstanding voting stocks or shares in both of them. One of them directly, indirectly controls others. Both of them are directly, indirectly controlled by a third person. Together, they directly and indirectly control the third person, and they are members of the same family. Explanation: term person also includes a legal person. Explanation: person who is associated with the business of one another in one of the sole agent or sole distributor or sole consignor. However, described on the other shall be deemed to be related to the purpose of these rules if they falls within the criteria of the sub-rule. Illustration: IES Limited imported certain goods of US or 20 per unit from the exporter who is holding 30% equity in the same share capital of the importer's company. Subsequently, the assessee entered into agreement with the same exporters to import the said quantity in bulk at 14 per unit. The importer on the reduced price are affected pursuant to the agreement. The department rejected the transaction value and stated that the price was inflated by the relationship and completed to assessment based on the transaction value earlier imported 20 per unit under the rule for a customs valuation. State briefly the department action in the substantial law. No, the department action is not substantial law. Subsection 2 of customs valuation determine the value of imported goods. Inter alia provides a person shall be deemed to be related if one of them directly or indirectly control interest. The word control has not been identified under the set rules. As per the common parallel, the control is established only the established enterprise hold 51% of the equity of the sharing capital of the equity shareholding of the other company. However, the instance case, the exporter's company had only 30% of the shareholder of the company. Thus, the exporter company did not exercise control over the assessee. So, the two parties cannot be said to be related. The fact the assessee has made a bulk import could be a reason of reduction in imported price. The burden to prove under the valuation lies on the revenue and the absence of any evidence from the department to prove under valuation, and the price declared by the assessee is acceptable. In the light of foregoing discussion, it can be inferred that department action is not sustainable in law. Rule 3: Determination of the method of valuation. Subject to Rule 12, the value of imported goods can be transaction value adjusted to the accordance with the provision of Rule 10. The value of imported goods under sub-rule 1 shall be accepted for provided that there is no restriction as the disposition or use of the goods by the buyers other than the restriction with an imposed or required by law or the public authorities in India. Limit the geographical area in which goods may be resold do not substantially affect the value of the goods. The sale or price is not subject to some conditions or consideration for which value cannot be determined in respect of the goods being valued. Sale or a price is not subject to same condition or a consideration for which the value cannot be determined in respect of the goods being valued. No part for the produce of any subsequent resale, disposal or use of the goods by the buyers will accrue directly or indirectly to the seller, unless an appropriate adjustment can be made in accordance with the provision of Rule 10 of the Act. The buyer and the seller are not related. Where the buyer and sellers are related, the transaction value is accepted by the customs purpose of the provision of Sub-Rule 3. Where the buyer and seller are related, transaction value shall be acceptable provision provided that the examination of circumstances of the sale of the imported goods indicate that the relationship do not influence the price. The sale between the related parties and the transaction value shall be accepted. However, the importer demonstrate that the declared value of the goods has been valued closely approximate to the following values ascertained at or about the same time. Transaction value of the identical goods or the similar goods in the sale or up to unrelated party wasn't buyers in India. Detective value for identical goods or similar goods. Computed value of identical goods or similar goods. Provided that applying the value used for comparison due account should be taken for demonstration difference in the commercial level, the quantity level adjustment in accordance with the provision of the Rule 10 and cost incurred by the seller in sales which he and the buyer are not related. Substitute value shall not be established under the provision of the clause B or subrule. If the value cannot be determined under the provision of subrule 1, the value shall be determined by proceeding substantially through rule 4 to rule 9. Transaction value of identical goods. Subject to the provision of rule, the value of imported goods shall be the transaction value of imported goods subject to the value of identical goods sold or exported to India and imported at the same time at the goods being valued, provided that the transaction value shall not be valued at the goods provisionally assessed under Section 18 of the Customs Act 1982. In applying the rule, transaction value of identical goods on the sale of the same commercial level and substantially same quantity on the goods being valued and shall be used to determine the value of imported goods. Where no sale referred to the clause B or subrule 1 found, the transaction value of identical goods sold at a different commercial level or in a different quantity or both adjusted to take account of the differential attributes to commercial level or to the quantities column. So no sale referred to the clause B or rule 1 found the transaction value of the identical goods sold in a different commercial level or different quantities or both adjusted to take account of the different attributable to commercial level or to the quality or both shall be used, provided that such adjustment shall be made on the basis of demonstrated evidence which clearly establish that the reasonableness and accuracy of the adjustment, whether such adjustment leads to increase or decrease in value. When the cost and charges are referred to subrule 2 of rule 10 of the value includes the transaction value of identical goods. The adjustment shall be made if there is a significant difference in the cost and changes between the goods being valued and identical goods and question arising in difference in distance and measure means of transport. In applying the rules, more than one transaction value of identical goods is found, the lowest of the such value shall be used to determine the value of imported goods. Transaction value of identical goods sold for the export in India, imported at or about the same time the goods has been valued. Identical goods should be sold at the same commercial level and substantial at the same quantity. If sold in different commercial level quantity, then adjustment to be made for the difference. Adjustment to be made on account of difference in distance and means of transport used for import of identical goods. In the case of more than one transaction value or identical goods is available, lowest value can be considered. Subject to the provision of the Rule 3, the value of imported goods shall be a transaction value of similar goods sold for the export to India and imported at the or about the same time of the goods being valued. Provided that the transaction value shall not be the value of goods provisionally valued under subsection section 18 of Customs Tariff Act 1962. Provisionally clause B and C, subrule 1, subrule 2 and subrule 3, subrule 4, muta shall apply to respect of a similar goods. Rule 6. Determination of value where the values cannot be determined under the Rule 345. If the value of imported goods cannot be determined under the provision 345, then the value should be determined under the provision of Rule 7. And when the value cannot be determined under the rule and under Rule 8, the provision request to the importers and the approval from the proper officer with order of application of the Rule 7 Rule 8 shall be reversed. Detective value. Subject to the provision of the Rule 3, the goods being valued or identical or similar imported goods are sold in India. The condition of import at about the time at which deduction or determined value is presented, the value of imported goods shall be based on the unit price at the imported goods are identical or similar imported goods sold in the greatest aggregate quantity to the person who are not related to the seller in India, subject to the following deductions. Either the commission usually paid or agreed to be paid or addition should be made for profit and general expenses in the connection with the sales in India of imported goods or the same class of kinds. Usual cost of transportation, insurance, associated costs included within India. The customs duty and other taxes paid in India for the region of the imported and sale of the goods. If either the imported goods nor the identical nor similar imported goods are sold at or after the same time of importation of the goods being valued, the value of imported goods shall subject to otherwise a provision of some rule 1. The basis of the unit at which the imported goods are identical or similar imported goods are sold in India at least date after importation but before the expiry of 90 days after such importation. So golden day India at the earliest day of importation but not expire 90 days. If neither the importation goods nor identical nor similar imported goods are sold in India and the condition of imported, then the value shall be based on the unit price at which imported goods after further processing are sold in the greatest aggregate quantity to the person who is not related to the seller in India. In such a determination, due allowances shall be made for the value added for processing and deduction purposes for the item 1 to 3 for sub-rule 1. Rule 8 Computed value. Subject to the provision of Rule 3, the value of imported goods shall be based on the computed value, which shall consist the sum of A, B, C, cost of value material and fabrication of such or processing employed in the production of the import goods, and sum of the amount of the profit of general expenses equal to the usual reflected in the sale of goods or the same class or kind of goods being valued, which is made by the producer in the country of exportation exportation from export to India, and sum of cost or value of other expenses and sub rule 2 of rule 10. Residual method. Subject to the provision of Rule 3, where the value of imported goods cannot be determined under the provision of any of the preceding rules, value shall be determined using a reasonable method, consistent with the principles and general provision of the rules and the basis of the data available in India. Provided that the value so determined shall not exceed the price at which such goods are ordinarily sold or offered to sale for delivery at the time and place of importation in the course of international trade. When the seller and buyer has no interest in the business and other prices and another, the price is the sole consideration for the sale or the offer for sale. No value shall be determined under the provision of the rule under the basis of selling price in India and the goods produced in India. Selling price in India of the goods is in India. No value shall be determined under the provision of the rule on the basis of selling price of the goods produced in India on the basis of system which provides for the acceptance of customs purpose of the highest of the two alternative values. No value shall be determined for the provision of the rule on the basis of the price of goods on the domestic market of the country of exportation. No value shall be determined on the provision of the rule the cost of production other than the computed value which has been determined for identical or similar or in accordance with the provision of rule. On the no value shall be determined on the provision of the rule on the basis of the price of the goods export of the country other than India. Minimum custom value, arbitrage of fixation value. Rule 10 Cost of service. Determining the transaction value, that is cost and services. Determine the transaction value where the shall be added to price actually paid or payable on the imported goods. The following to the extent they are incurred by the buyers but are not included in the price are actually paid or payable for the imported goods. Commission, brokerage except buying commission. Cost of containers which treated as being one of the goods purposes on the goods of questions and goods in questions, and the cost of packing whether for labor material. The value appropriate or approximate of the following goods and services that are supplied directly indirectly by the buyer free of charge or reduced cost for use in connection with the production, sale of export of imported goods to the extent that such value has not been included in the price actually paid or payable, namely materials, components, parts, and similar items imported in the imported goods. Tools, dies, mounts, similar items used in the production of the imported goods. Material consumed in the production of the imported goods. Engineering, development, artwork, design work, plans, sketches undertaken elsewhere than India, necessary for the production of the imported goods. Royalties and license fees related to the imported goods that the buyers is required to pay directly and indirectly as a connection of the sale of the goods being valued to the extent of such royalties and fees not being included in the price actually paid or payable. The value of any of the part of the proceed of any of subsequent resale, disposal or use of the imported goods than accrued directly and indirectly by the reseller. All other payments actually made or to be made in condition of sale of the imported goods by the buyers to the seller or the buyer to the third party to satisfy the obligation of the seller to the extent that such payments are not included in the price actually paid or payable. Any other payments made on the condition of sale of the imported goods by the buyer to the seller or by the buyer to third party to satisfy the obligation of the seller to the extent that such payments are not included in the price actually paid or payable. Explanation: where the royalties, license fees, or any other payment or the process, whether pertained otherwise or includable, refer to the clause, or such charges shall be added to the price actually paid or payable. Imported goods. Imported goods are notwithstanding the fact such goods may be subject to the process of importation of such goods. For the purpose of subsection 1, section 14 Customs Act 1962 and the value of the imported goods shall be value of such goods and shall include cost of transportation, loading, unloading, handling charges associated with the delivery of the imported goods to the place of import, cost of insurance to the place of importation. However, when the cost referred to the clause A is not ascertainable, such a cost shall be less than 20% of fees of board value of the goods. Further, where there is a free of board, value of the goods are not ascertainable, but a sum of free of board, value of the goods, and the cost referred to the clause A is ascertainable, the cost referred to the clause A shall be 20% of the sum. When the cost referred to the clause B is not ascertainable, such cost shall be 1.25% of cost of board value of the goods. Where the free of board value of the good is not ascertainable, but the sum of free of board value of goods as the cost referred to the clause A is ascertainable. The cost of the clause B shall be 1.125% of the sum. In the case of goods imported by air, where the cost referred to the ascertainable, such cost shall not exceed 20% of the free of board of the cost. In the case of goods imported by sea or air or transshipped to another custom station in India, the cost of insurance, transport, loading, unloading, handling charges associated with such transaction shall be excluded. Explanation: the cost of transportation of imported goods referred to clause A includes ship demurrage charges, chartered vehicles, letterage, or barge charges.